Government-owned and controlled corporation, GOCC. It refers to any agency organized as a stock or non-stock corporation, vested with functions relating to public needs, whether governmental or proprietary in nature, and owned by the government directly or through its instrumentalities either wholly or where applicable as in the case of stock corporations, or to the extent of at least 51% of its capital. Note: government instrumentality may include a GOCC, and there may be instrumentality that does not qualify as GOCC. Taxability of GOCCs. GOCCs perform proprietary functions, hence they are subject to taxation. However, certain corporations have been granted exemption under Section 27C of RA 8424 as amended by RA 9337, which took effect on July 1, 2005 to wit: Number 1. Government Service Insurance, GSIS, Social Security System, SSS, Philippine Health Insurance Corporation, PHIC, Sweepstakes Charity Sweepstakes Office, BCSO. Constitutional limitations. Taxation being inherent in sovereignty need not be clothed with any constitutional authority for it to be exercised by the sovereign state. Instead, constitutional provisions are meant and intended more to regulate and define rather than to grant the power emanating therefrom. Provisions directly affecting taxation. Prohibition against imprisonment for non-payment of poll tax. Basis: no person shall be imprisoned for debt or non-payment of poll tax. Article 3, Section 20. A poll tax is one levied on persons who are residents within the territory of the taxing authority without regard to their property, business, or occupation. Thus, only the basic community tax under the LGC could qualify as a poll tax, and the non-payment of other additional taxes imposed, not being in the nature of poll taxes, may validly be subjected by law to imprisonment. In other words, while a person may not be imprisoned for non-payment of a cedula or poll tax, he may be imprisoned for non-payment of other kinds of taxes, where the law so expressly provides. Uniformity and equality of taxation. Basis: the rule of taxation shall be uniform and equitable. The Congress shall evolve a progressive system taxation. Explain the following concepts in taxation. Number 1, uniformity. Number 2, equitability. Number 3, equality. Uniformity: it means that all taxable articles or kinds of property of the same class shall be taxed at the same rate. A tax is considered uniform when it operates with the same force and effect in every place where the subject is found. Different articles may be taxed at different amounts provided that the rate is uniform on the same class everywhere, with all people at all times. Equitability: taxation is said to be equitable when its burden falls on those better able to pay. Equality: it is accomplished when the burden of the tax falls equally and impartially upon all persons and property subject to it. Question: explain the requirement of uniformity as a limitation in the imposition and/or collection of taxes. Answer: uniformity in the imposition and/or collection of taxes means that all taxable articles or kinds of property of the same class shall be taxed at the same rate. The requirement of uniformity is complied with when the tax operates with the same force and effect in every place where the subject of it is found. Different articles may be taxed at different amounts, provided that the rate is uniform on the same class everywhere, with all people at all times. Accordingly, singling out one particular class for taxation purposes does not infringe the requirement of uniformity. Accordingly, singling out one particular class for taxation purposes does not infringe the requirement of uniformity. Question: a law was passed exempting doctors and lawyers from the operation of the value-added tax. Other professionals complained and filed a suit questioning the law for being discriminatory and violative of the Equal Protection Clause of the Constitution. Since complainants were not given the same exemption, is the suit meritorious or not? Reason briefly. Answer: yes, the suit is meritorious. The VAT is designed for economic efficiency, hence should be neutral to those who belong to the same class. Professionals are a class of taxpayer by themselves, who in compliance with the rule of equality of taxation must be treated alike for tax purposes. Exempting lawyers and doctors from a burden to which other professionals are subjected will make the law discriminatory and violative of the Equal Protection Clause of the Constitution, while singling out a class for taxation purposes will not infringe upon this constitutional limitation. Singling out a taxpayer from a class will no doubt transgress the constitutional limitation. Ormoc Sugar Company versus Treasurer of Ormoc City. Treating doctors and lawyers as a different class of professionals will not comply with the requirements of a reasonable, hence valid classification, because the classification is not based upon substantial distinction which make real differences. The classification does not comply with the requirement that it should be germane to the purpose of the law either. Pepsi Cola Bottling Company versus City of Butuan. Progressive taxation. Taxation is progressive when tax rate increases as the income of the taxpayer increases. It is based on the principle that those who are able to pay more should shoulder the bigger portion of the tax burden. Question: does the Constitution prohibit regressive taxes? Answer is no. The Constitution does not really prohibit the imposition of regressive taxes. What it simply provides is that Congress shall evolve a progressive system of taxation. Meaning of evolve as used in the Constitution. The constitutional provision has been interpreted to mean simply that direct taxes are to be preferred, and as much as possible, indirect taxes should be minimized. The mandate of Congress is not to prescribe, but to evolve a progressive tax system. This is a mere directive upon Congress, not a justiciable right or a legally enforceable one. We cannot avoid regressive taxes, but only minimize them. Question: is VAT regressive? Answer is yes. The principle of progressive taxation has no relation with the VAT system inasmuch as VAT paid by the consumer or business for every goods bought or services enjoyed is the same regardless of income. In other words, the VAT paid is the same portion of an income, whether big or small. The disparity lies in the income earned by a person or profit margin marked by a business, such that the higher the income or profit margin, the smaller the portion of the income or profit that is eaten by VAT. A converse, the lower the income or profit margin, the bigger the part of the VAT eats away. At the end of the day, it is really the lower income group of business or business with low profit margin that is always hardest hit. Abacada Guru versus Ermita. Number 3. Grant by Congress of authority to the President to impose tariff rates. Basis: the Congress may, by law, authorize the President to fix within specified limits and subject to such limitations and restrictions as it may impose tariff rates, import and export quotas, tonnage, and wharfage dues, and other duties or imposts within the framework of the National Development Program of the Government. Article 6, Section 28, Number 2. Flexible Tariff Clause. This clause provides the authority given to the President to adjust tariff rates under Section 401 of the Tariff and Custom Code, now Section 1608 of RA 10863, known as the Custom Modernization and Tariff Act. This authority, however, is subject to limitations and restrictions indicated within the law itself. Requisites on the authority of the President in imposing tax. A. Delegated by Congress through a law. The authorization granted to the President must be embodied in a law. Hence, the justification cannot be supplied simply by inherent executive powers. It is Congress which authorizes the President to impose tariff rates, import and export quotas, tonnage and wharfage dues, and other duties or imposts. Thus, the authority cannot come from the Finance Department, the National Economic Development Authority, or the World Trade Organization, no matter how insistent or persistent these bodies may be. B. Subject to congressional limits and restrictions, the authorization to the President can be exercised only within the specified limits set in the law and is further subject to limitations and restrictions which Congress may impose. Consequently, if Congress specifies that the tariff rates should not exceed a given amount, the President cannot impose a tariff rate that exceeds such amount. Assuming there is a conflict between the specific limitation in the Constitution and the general executive power of control and supervision, the former prevails in the specific instance of safeguard measures such as tariff and impost, and would thus serve to qualify the general grant to the President of the power to exercise control and supervision over his or her subalterns. Southern Cross Cement Corporation versus Cement Manufacturers Association of the Philippines. Number C. Within the framework of National Employment Program, prohibition against taxation of religious, charitable entities and educational entities. Basis: charitable institutions, churches and personages, or convents pertinent to 32. Mosques, non-profit cemeteries, and all lands, buildings, and improvements actually directly and exclusively used for religious, charitable, or educational purposes shall be exempt from taxation. Article 4, Section 28, Number 3. Question: what is the coverage of tax exemption? It covers real property taxes only. Accordingly, a conveyance of such exempt property can be subject to transfer taxes. Properties exempt under the Constitution from the payment of property taxes: charitable institution; 2. Churches and personages or convents appurtenant thereto; 3. Mosques; 4. Nonprofit cemeteries; 5. All lands, buildings, and improvements actually, directly, and exclusively used for religious, charitable, or educational purposes shall be exempt from taxation. Meaning of charitable: it is not restricted to relief of the poor or sick. The test whether an enterprise is charitable or not is whether it exists to carry out a purpose recognized in law as charitable, or whatever it is maintained for gain, profit, or private advantage. Lang Center of the Philippines versus Quezon City. Also, an organization must meet the substantive test of charity. Charity is essentially a gift to an indefinite number of persons, which lessens the burden of government. In other words, charitable institutions provide for free goods and services to the public, which would otherwise fall on the shoulders of government. CIR versus St. Luke's Medical Center. Meaning of actual, direct, and exclusive use of the property for religious, charitable, and educational purposes. It is the direct and immediate and actual application of the property itself to the purposes for which the charitable institution is organized. It is not the use of the income from the real property that is determinative of whether the property is used for tax-exempt purposes. Note: in the case of Lang Center of the Philippines versus City Assessor of Quezon City, the court ruled that under the 1987 Constitution, for lands, buildings, and improvements of the charitable institution to be considered exempt, the same should not only be exclusively used for charitable purposes, it is required that such property be used actually and directly for such purposes. Exclusive is defined as possessed and enjoyed to the exclusion of others, debarred from participation or enjoyment, and exclusively is defined in a manner to exclude as enjoying a privilege exclusively. If real property is used for one or more commercial purposes, it is not exclusively used for the exempted purpose, but it is subject to taxation. The words dominant use or principal use cannot be substituted for the words use exclusively without doing violence to the Constitution and the law. In sum, the court ruled that the portion of the land leased to private entities as well as those parts of the hospital leased to private individuals are not exempt from taxes. Rules on taxation of non-stock corporations for charitable and religious purposes. 1. For purposes of income taxation, the income of non-stock corporations operating exclusively for charitable and religious purposes, no part of which inures to the benefit of any member, organizer, or officer, or any specific person, shall be exempt from tax. However, the income of whatever kind and nature from any of their properties, real or personal, or from any of their activities for profit regardless of the disposition made of such income, shall be subject to tax. Section 30E and last paragraph at NIRC. Note: an organization may be considered as non-profit if it does not distribute any part of its income to stockholders or members. However, despite its being a tax-exempt institution, any income such institution earns from activities conducted for profit is taxable, as expressly provided in the last paragraph of Section 30 CIR versus St. Luke's Medical Center. Donations received by religious, charitable, and educational institutions are considered as income but not taxable income, as they are items of exclusion. On the part of the donor, such donations are a deductible expense, provided that no part of the income of which inures to the benefit of any private stockholder or individual in an amount not exceeding 10% in case of individual and 5% in case of a corporation of the taxpayer's taxable income derived from trade or business or profession. For purposes of donors and estate taxation, donation in favor of religious and charitable institutions are generally not subject to tax, provided, however, that not more than 30% of the said bequest, device, or legacy or transfer shall be used for administration purposes. Question: in 1991, Imelda gave her parents a Christmas gift of 100,000 and a donation of 80,000 to the parish church. She also donated a parcel of land for the construction of a building to the PUP Alumni Association, a non-stock non-profit organization. Portions of the building shall be leased to generate income for the association. Question: is a Christmas gift of 100,000 to Imelda's parents subject to tax? How about the donation to the parish church? How about the donation to the PUP Alumni Association? Answer: the Christmas gift of 100,000 given by Imelda to her parents is not taxable because under the law, net gifts not exceeding 100,000 are exempt. The donation of 80,000 to the parish church even is tax exempt, provided that not more than 30% of the said bequest shall be used by such institution for administration purposes. The donation to the PUP Alumni Association does not also qualify for exemption, both under the Constitution and the aforecited law, because it is not an educational or research organization, corporation, institution, foundation, or trust. Question: the Constitution exempts from taxation charitable institutions, churches, personages, or convents appertinent thereto, mosques and non-profit cemeteries and lands, buildings and improvements actually directly and exclusively used for religious, charitable, or educational purposes. Mercy Hospital is a 100-bed hospital organized for charity patients. Can said hospital claim exemption from taxation under the provision? Answer is yes. Mercy Hospital can claim exemption from taxation under the provision of the Constitution, but only with respect to real property taxes, provided that such real properties are used actually, directly, and exclusively for charitable purposes. Question: Article 6, Section 28, Number 3 of the Constitution provides that charitable institutions, churches, and personages or covenants appertinent thereto, mosques, nonprofit cemeteries, and all lands, buildings, and improvements actually, directly, and exclusively used for religious, charitable, or educational purposes shall be exempt from taxation. To what kind of taxes does this exemption apply? Answer: this exemption applies only to property taxes. What is exempted is not the institution itself, but the lands, buildings, and improvements actually, directly, and exclusively used for religious, charitable, and educational purposes. Question: the Roman Catholic Church owns a 2-hectare lot in a town in Tarlac Province. The southern side and middle part are occupied by the church and a convent. The eastern side by the school run by the church itself, the southeastern side by some commercial establishment, while the rest of the property, in particular the northwestern side, is idle or unoccupied. May the church claim tax exemption on the entire land? Answer is no. The portion of the land occupied and used by the church, convent, and school run by the church are exempt from real property taxes, while the portion of the land occupied by commercial establishment and the portion which is idle are subject to real property taxes. The usage of the property and not the ownership is a determining factor whether or not the property is taxable. Long Center of the Philippines versus Quezon City. Summary: rules on exemption on properties actually, exclusively, and directly used for religious, educational, and charitable purposes. Coverage of constitutional provision covers real property tax only, the income of whatever kind and nature from any of their properties, real or personal, or from any of their activities for profit, regardless of the disposition made of such income, shall be subject to tax. Requisite to avail of this exemption: property must be actually, directly, and exclusively used by religious, charitable, and educational institution. Test for the grant of this exemption: use of the property for such purposes, not the ownership thereof. Note: under the 1987 Constitution, the doctrine of exemption by incidental purpose is no longer applicable. Such doctrine is only applicable to cases where the cause of action arose under the 1935 Constitution. Under the 1987 Constitution, it must be proved that the properties are actually, directly, and exclusively used for the purpose of institution for the exemption to be granted. Prohibition against taxation of non-stock, non-profit educational institution. Basis: all revenues and assets of non-stock, non-profit educational institutions used actually, directly, and exclusively for educational purposes shall be exempt from taxes and duties, subject to conditions prescribed by law. All grants, endowments, donations, or contributions used actually, directly, and exclusively for educational purposes shall be exempt from tax. Actually, directly, and exclusively used. The use of the term actually, directly, and exclusively used referring to religious institutions cannot be applied to non-stock, non-profit educational institutions. The provisions of Article 6, Section 28, Number 3 applies to religious, charitable, and educational institutions, while Article 14 applies solely to non-stock, non-profit educational institutions. Hence, in this case, we should apply its literal interpretation solely in consonance with the principle of strictissimi juris. The word exclusively indicates that the provision is mandatory. Article 14, Section 4.3, grantee, non-stock, non-profit educational institution. Article 6, Section 28, religious, educational, charitable. Taxes granted under Article 14, Section 4, income tax, custom duties, property tax. Tax granted under Article 6, Section 28, property tax. Note that a careful analysis of the last paragraph of Section 30 of the NIRC, as amended by RA 8424, would reveal that the income of whatever kind of or character derived by non-stock and non-profit educational institutions from any of their properties, real or personal, or from any of their activities conducted for profit, regardless of the disposition thereof, shall be subject to tax. However, under Article 14, Section 4, Number 3 of the Constitution, revenues and assets actually, directly, and exclusively used for educational purposes shall be exempt from taxes and duties. Last paragraph of Section 30 of the NIRC disregarded this requisite of use and instead used the phrase regardless of the disposition. Ergo, Section 30H is in relation to the last paragraph of the NIRC appears to be unconstitutional. NIRC should yield to the provision of the 1987 Constitution granting tax exempt to non-stock, non-profit educational institutions. The Constitution is the basic and paramount law to which all other laws must conform. Donors tax, estate tax, VAT, and other taxes. Article 14, Section 4, which provides that all grants, endowments, donations, or contributions used actually, directly, and exclusively for educational purposes shall be exempt from tax, is not self-executing, as it requires legislative enactment providing certain condition for exemption. However, since Section 101, letter A, number 3 of NIRC under donors tax declared its exemption, then these donations are tax exempt. Under the estate tax, non-stock, non-profit educational institutions are not included under the exempt transfer mortis causa, hence they are not tax exempt. Under RR number 697, once non-stock, non-profit educational institutions engage in business, they are subject to VAT. Pursuant to Section 109M, private educational institutions shall be exempt from VAT, provided they are accredited as such either by DepEd or CHED. However, this does not extend to other activities involving the sale of goods and services. However, they shall be subject to internal revenue taxes on income from trade, business, or other activity, the conduct of which is not related to the exercise or performance of their educational purposes or functions. Q. Under Article 14, Section 4, Number 3 of the 1987 Constitution, all revenues and assets of non-stock, non-profit educational institutions used actually, directly, and exclusively for educational purposes are exempt from taxes and duties. Our incomes derived from dormitories, canteens, and bookstores, as well as interest income on bank deposit and yields from deposits substitute automatically exempt from taxation? Answer is no. The interest income on bank deposits and yields from deposit substitutes are not automatically exempt from taxation. There must be a showing that the incomes are used actually, directly, and exclusively for educational purposes. The income derived from dormitories, canteens, and bookstores are not also automatically exempt from taxation. There is still a requirement for evidence to show actual, direct, exclusive use for educational purposes. Note, the 1987 Constitution does not distinguish with respect to the source or origin of the income. The distinction is with respect to the use, which should be actual, direct, exclusive for educational purposes. Where the Constitution does not distinguish with respect to source or in origin, the NIRC should not make distinction. tax on proprietary nonprofit educational institution and proprietary nonprofit hospitals. Section 27B of the NIRC did not remove the exemption from income tax of proprietary nonprofit hospitals as charitable institutions. The provision merely introduced the preferential income tax rate of 10% for proprietary nonprofit educational institutions and proprietary nonprofit hospitals. Proprietary, private, nonprofit, no net income or asset accrues to or benefits any member of specific person with all the net income or asset devoted to the institution's purposes and its activities conducted not for profit. Charitable institutions, one providing for free goods and services to the public which would otherwise fall on the shoulders of the government. Tax rate of proprietary nonprofit educational institutions and proprietary nonprofit hospitals. 30%. Private, nonprofit hospitals, and educational institutions whose gross income from unrelated trade, business, or other activity exceeds 50% of total gross income from all sources. Hospitals and educational institutions claiming to be proprietary nonprofit but do not meet their definition thereof. 10%. Private, nonprofit hospitals, and educational institutions whose gross income from unrelated trade, business, or other activity does not exceed 50% of total gross income from all sources. Exempt, organized and operated exclusively for charitable purposes, and no part of its net income or assets shall belong to or inure to the benefit of any member, organizer, officer, or any specific purpose. Majority vote of Congress for grant of tax exemption. Basis: no law granting any tax exemption shall be passed without the concurrence of a majority of all the members of Congress. That is Section 28, Number 4, Article 6. The inherent power of the state to impose taxes carries with it the power to grant tax exemption. Granting of exemptions. Exemption may be created 1. By the Constitution, or 2. By statute, subject to limitations as the Constitution may provide. Required vote for grant of tax exemption. In granting tax exemptions, the absolute majority vote of all the members of Congress is required. It means at least 50% plus 1 of all members voting separately. Article 6, Section 28, Number 4, 1987 Constitution. Tax amnesties, tax condonations, and tax refunds are in the nature of tax exemptions. Such being the case, the law granting tax amnesties, tax condonations, and tax refunds require the vote of an absolute majority of the members of the Congress. Reason for the separate vote for Senate and Congress: because the sheer number of congressmen would dilute the vote for the senators. Required vote for withdrawal of such grant of tax exemption. A relative majority or plurality of votes is sufficient, that is, majority of a quorum. Prohibition of use of tax levied for special purposes. Basis: all money collected on any tax levied for a special purpose shall be treated as special fund and paid out for such purpose only. If the purpose for which a special fund was created has been fulfilled or abandoned, the balance, if any, shall be transferred to the general funds of the government. Section 29. Number 3, Article 6. Note: in Gaston versus Republic Planters Bank, the court ruled that the stabilization fees collected by the state for the promotion of sugar industry were in the nature of taxes, and no implied trust was created for the benefit of sugar industries. Thus, the revenues derived therefrom are to be treated as a special fund to be administered for the purpose intended. No part thereof may be used for the exclusive benefit of any private person or entity, but for the benefit of the entire sugar industry. Once the purpose is achieved, the balance, if any remaining, is to be transferred to the greater general funds of the government. President's veto power on: number 1, appropriation; number 2, revenue; number 3, tariff bills. Basis: the President shall have the power to veto any particular item or items in an appropriation, revenue, or tariff bill, but the veto shall not affect the item or items which he does not object. The item or items vetoed shall be returned to the lower house of Congress together with the objection of the President. If after consideration two-thirds of all the members of such house shall agree to pass the bill, it shall be sent together with the objection to the other house, by which it shall likewise be considered, and if approved by two-thirds of all the members of that house, it shall become a law. Non-impairment of jurisdiction of a Supreme Court basis. The Supreme Court shall have the power to review, revise, reverse, modify, or affirm or appeal on certiorari as the laws of the rules of court may provide, final judgment or orders of lower courts in all cases involving the legality of any tax, imposed, assessment, or toll, or any penalty imposed in relation thereto. Article 8, Section 5, letter Number 2, letter B. Note: these jurisdictions are concurrent with the RTCs, thus the petition should generally be filed with the RTC following the hierarchy of courts. However, questions on tax laws are usually filed direct with the Supreme Court, as these are impressed with paramount public interest. It is also provided under Article 6, Section 30 of the Constitution that no law shall be passed increasing the appellate jurisdiction of the Supreme Court without its advice and concurrence. The courts cannot inquire into the wisdom of a taxing act except when there is an allegation of violation of constitutional limitations or restrictions. Grant of power to the LGUs to create its own source of revenue. Basis: each LGU shall have the power to create its own sources of revenues and to levy taxes, fees, and charges subject to such guidelines and limitations as the Congress may provide, consistent with the basic policy of local autonomy. Such taxes, fees, and charges shall accrue exclusively to the local governments. Justification in the delegation of legislative taxing power to local governments. Delegation of legislative taxing power to local governments is justified by the necessary implication that the power to create political corporations for purposes of local self-government carries with it the power to confer on such local government agencies the authority to tax. Exemption to non-delegation of legislative powers. The general principle against the delegation of legislative powers as a consequence of the principle of separation of powers is subject to one well-established exemption. Legislative powers may be delegated to LGUs. Included in this grant of legislative power is the grant of local taxing power. Question: may Congress under the 1987 Constitution abolish the power to tax of local governments? Answer is no. The Congress cannot abolish the local government's power to tax, as it cannot abrogate what is expressly granted by the fundamental law. The only authority conferred to Congress is to provide the guidelines and limitations on the local government's exercise of the power to tax. The local government's power to tax is the most effective instrument to raise the needed revenues. The right of LGUs to collect taxes due must always be upheld to avoid severe tax erosion. This consideration is consistent with the state policy to guarantee the autonomy of the local government and the objective of the LGC that they enjoy genuine and meaningful local autonomy to empower them to achieve their fullest development as self-reliant communities and make them effective partners in the attainment of national goals. Origin of revenue and tariff bills. Basis: all appropriation, revenue or tariff bills, bills authorizing increase of the public debt, bill of local application, and private bills shall originate exclusively in the House of Representatives, but the Senate may propose or concur with amendments. What is required to originate in the House of Representatives is not the law, but the revenue bill, which must originate exclusively in the lower house. The bill may undergo such extensive changes that the result may be a rewriting of the whole. The Senate may not only concur with amendments, but also propose amendments. To deny the Senate's power not only to concur with amendments, but also to propose amendments would be to violate the co-equality of the legislative power of the two houses of Congress, and in fact make the House superior to the Senate. Why must appropriation, revenue, or tariff bill originate from the Congress? Answer: on the theory that elected as they are from the districts, the members of the House of Representatives can be expected to be more sensitive to the local needs and problems. Question: mounting budget deficit, revenue generation, inadequate fiscal allocation for education, increased emoluments for health workers, and wider coverage for full VAT benefit are the reasons why RA 9337 was enacted. RA 9337 is a consolidation of three legislative bills, namely HB number 3555 and 3507 and SB number 1950. Because of the conflicting provisions of the proposed bills, the Senate agreed to the request of the House of Representatives for a committee conference. The conference committee on the disagreeing provision of House bill recommended the approval of its report, which the Senate and the House of the Representatives did. Does RA 9337 violate Article 6, Section 24 of the Constitution and exclusive origination of revenue bills? Does RA 9337 violate Article 6, Section 26, Number 2 of the Constitution on the no amendment rule? Answer is no. It was HB numbers 3555 and 3705 that initiated the move for amending provisions of the NIRC, dealing mainly with the VAT. Upon transmittal of said House bills to the Senate came out with SB number 1950, proposing amendments not only to NIRC provisions on the VAT but also amendments to NIRC provisions on other kinds of taxes. Since there is no question that the revenue bill exclusively originated in the House of Representatives, the Senate was acting within its constitutional power to introduce amendments to the House bill when it included provisions in SB number 1950, amending corporate income taxes, personage, excise, and franchise taxes. Verily, Article 6 Section 24 of the Constitution does not contain any prohibition or limitation on the extent of the amendments that may be introduced by the Senate of the House Revenue Bill. The Senate can propose amendments, and in fact, the amendments made are germane to the purpose of the House bills, which is to raise revenues for the government. The sections introduced by the Senate are germane to the subject matter and purposes of the House bills, which is to supplement our country's fiscal deficit, among others. Thus, the Senate acted within its power to propose such amendments. Number 2. Answer is no. The no amendment rule refers only to the procedure to be followed by each House of Congress with regard to bills initiated in each of said respective houses before said bill is transmitted to the other house for its concurrence or amendment. Verily, to construe said provision in a way as to prescribe any further changes to a bill after one house has voted on it would lead to absurdity, as this would mean that the other house of Congress would be deprived of its constitutional power to amend or introduce changes to said bill. Thus, Article 6, Section 26, Number 2 of the Constitution cannot be taken to mean that the introduction by the bicameral conference committee of amendments and modification to disagreeing provisions in bill that have been acted upon by both houses of Congress is prohibited. No appropriation or use of public money for religious purposes basis. No public money or property shall be appropriated, applied, paid, or employed directly or indirectly for the use, benefit, or support of any sect, church, denomination, sectarian institution, or system of religion, or of any priest, preacher, minister, or other religious teacher or dignitary as such, except when such priest, preacher, minister, or dignitary is assigned to the armed forces or to any penal institution or government orphanage or leprosarium. This is in consonance with the inviolable principle of separation of church and state, provisions indirectly affecting taxation. Due process basis. No person shall be deprived of life, liberty, or property without due process of law. Requirement of due process in taxation. Substantive due process. Tax must be for public purpose. It must be imposed within territorial jurisdiction. Procedural. No arbitrariness or oppression either in the assessment or collection. Question. When is deprivation of life, liberty, and property by the government done in compliance with due process? Answer. If the act is done under authority of a law that is valid or the Constitution itself, substantive due process, and after compliance with fair and reasonable methods of procedure prescribed by law, procedural due process. Q. When may violation of due process be invoked by the taxpayer? Answer. The due process clause may be invoked where a taxing statute is so arbitrary that it finds no support in the Constitution, as where it can be shown to amount to a confiscation of property, Reyes versus Almazor. While it is true that the Philippines as a state is not obliged to admit aliens within its territory, once an alien is admitted, he cannot be deprived of life without due process of law. This guarantee includes the means of livelihood. The shelter of protection under the Due Process and Equal Protection Clause is given to all persons, both aliens and citizens. Illustrative cases of violation of Due Process Clause: 1. Tax amounting to confiscation of property. 2. Subject of confiscation is outside the jurisdiction of the taxing authority. 3. Law is imposed for a purpose other than a public purpose. 4. Law which is applied retroactively imposes unjust and oppressive taxes. 5. The law is in violation of inherent limitations. Equal protection. Basis: no person shall be denied the equal protection of the laws. Define equal protection of the law. It means that all persons subjected to such legislation shall be treated alike under like circumstances and conditions, both in the privileges conferred and in the liabilities imposed. The power to select subjects of taxation and apportion the public burden among them includes the power to make classifications. The inequalities which result in the singling out of one particular class for taxation or exemption infringe no constitutional limitation. Lutz versus Araneta, GR number 7859. Requisites of a valid classification: 1. Apply both for present and future conditions. 2. Apply equally to all members of the same class. 3. Must be germane to the purpose of the law. 4. Must be based on substantial distinction. Q. Is Revenue Memorandum Circular number 4791 classifying copra as an agricultural non-food product discriminatory and violative of the Equal Protection Clause? Answer: no. It is not violative and not discriminatory because there is a material or substantial difference between coconut farmers and copra producers on one hand and copra traders and dealers on the other. The former produce and sell copra, the latter merely sells copra. The Constitution does not forbid the differential treatment of persons so long as there is reasonable basis for classifying them differently. Misamis Oriental Association of Cocoa Traders versus Secretary of Finance. Principle of equality. It admits of classification or distinctions as long as they are based upon real and substantial differences between the persons. Property or privileges and those not taxed must bear some reasonable relation to the object or purpose of legislation or to some permissible government policy or legitimate end of the government. Q. What is the rational basis test? Explain briefly. The rational basis test is applied to gauge the constitutionality of an assailed law in the face of an equal protection challenge. It has been held that in areas of social and economic policy, a statutory classification that neither proceeds along suspect lines nor infringes constitutional rights must be upheld against equal protection challenge if there is any reasonable conceivable state of facts that could provide a rational basis for the classification. Under the rational basis test, it is sufficient that the legislative classification is rationally related to achieving some legitimate state interest. Q. RC is a law-abiding citizen who pays his real estate taxes promptly. Due to a series of typhoons and adverse economic condition, an ordinance is passed by MMCD granting 50% discount for payment of unpaid real estate taxes for the preceding year, and the condonation of all penalties on fines resulting from the late payment. Arguing that the ordinance rewards delinquent taxpayers and discriminates against prompt ones, RC demands that he be refunded an amount equivalent to one-half of the real estate he paid, the real taxes he paid. The municipal attorney rendered an opinion that RC cannot be reimbursed because the ordinance did not provide for such reimbursement. RC files suit to declare the ordinance void on the ground that it is class legislation. Will a suit prosper? No. The remission or condonation of taxes due and payable to the exclusion of taxes already collected does not constitute unfair discrimination. Each set of taxes is a class by itself, and the law would be open to attack as class legislation only if all taxpayers belonging to one class were not treated alike. Q. An EO was issued pursuant to law granting tax and duty incentive only to businesses and residents within the secured area of the economic special zone, and denying said incentives to those who live within the zone but outside such secured area, is a constitutional right to equal protection of the law violated by the executive order? Answer: no. Equal protection of the law clause is subject to reasonable classification. Classification to be valid must: 1. Rest on substantial distinction; 2. Be germane to the purpose of the law; 3. Not to be limited to existing conditions only; 4. Apply equally to all members of the same class. There are substantial differences between big investors being enticed to the secured area and the business operators outside that area in accord with the Equal Protection Clause that does not require territorial uniformity of laws. The classification applies equally to all the resident individuals and businesses within the secured area, the residents being in like circumstances to contributing directly to the achievement of the end, purpose of the law, are not categorized further. Instead, they are similarly treated both in privileges granted and obligation required. Q. The City Council of Ormoc enacted Ordinance Number 4, Series of 1964, taxing the production and exportation of only centrifugal sugar. At the time of the enactment, Plaintiff Ormoc Sugar was the only sugar central in Ormoc. Petitioner alleged that said ordinance is unconstitutional for being violative of the Equal Protection Clause. Is the ordinance valid? Answer: no. Equal Protection Clause applies only to persons or things identically situated and does not bar a reasonable classification of the subject of legislation. The classification to be reasonable should be in terms applicable to future conditions as well. The taxing ordinance should not be singular and exclusive as to exclude any substantially established sugar central of the same class as Ormoc Sugar Company from the coverage of the tax. Religious freedom. Basis: no law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. The free exercise and enjoyment of religious profession and worship without discrimination or preference shall be forever allowed. No religious test shall be required for the exercise of civil or political rights. Q. Is the real property tax exemption of religious organizations violative of the non-establishment clause? Answer is no. Neither the purpose nor the effect of the exemption is the advancement or the inhibition of religion, and it constitutes neither personal sponsorship nor hostility to religion. Q. Is the imposition of fixed license fee a prior restraint on the freedom of press and religious freedom? Answer is yes. As a license fee is fixed in the amount and unrelated to the receipts of the taxpayer, the license fee, when applied to a religious sect, is actually being imposed as a condition for the exercise of the sect's right under the Constitution. Q. Is the municipal license tax on the sale of Bibles and religious articles by a non-profit missionary organization at minimal profits valid? Answer: no. Such imposition of license tax constitutes curtailment of religious freedom and worship, which is guaranteed by the Constitution. Is VAT registration restrictive of religious and press freedom? No. The VAT registration fee, although fixed in amount, is not imposed for the exercise of a privilege, but only for defraying part of the cost of registration. Period. Non-impairment clause. Basis: no law impairing the obligation of contracts shall be passed. Instances when there is impairment of the obligation of contract: when the law changes the terms of the contract by 1. Making new conditions, 2. Changing conditions in the contract, or 3. Dispenses with the conditions expressed therein. Rationale for the non-impairment clause in relation to contractual tax exemption. When the state grants an exemption on the basis of contract, consideration is presumed to be paid to the state and the public is supposed to receive the whole equivalent therefore. Note: this applies only where one party is the government and the other party a private person. Rules regarding non-impairment of obligation and contract with respect to the grant of tax exemption. If the grant of the exemption is merely a spontaneous concession by the legislature, such exemption may be revoked. Number 2. If it is without payment of any consideration of the assumption of any new burden by the grantee, it is a mere gratuity, and exemption may be revoked. 3. However, if the tax exemption constitutes a binding contract and for valuable consideration, the government cannot unilaterally revoke the tax exemption. In Tolentino v. Secretary of Finance, the court ruled that RA 7716 EVAT law does not violate the non-impairment clause. The contention that the imposition of the VAT on the sales and leases of real estate by virtue of contracts entered into prior to the effectivity of the law would violate the constitutional provision that no law impairing the obligation of contracts shall be passed is without legal basis. The parties to a contract cannot fetter the exercise of taxing power of the state, for not only are existing laws read into contracts in order to fix obligations between parties, but the reservation of essential attributes of sovereign power is also read into contracts as a basic postulate of the legal order. The contract clause has never been thought as a limitation on the exercise of the state's power of taxation, save only where a tax exemption has been granted for a valid consideration. Question: X Corporation was the recipient in 1990 of two tax exemptions, both from Congress, one law exempting the company's bond issues from taxes and the other exempting the company from taxes in the operation of its public utilities. The two laws extending the tax exemptions were revoked by the Congress before the expiry date. Whether revocation constitutional? Answer is yes. The exempting statutes are both granted unilaterally by Congress in the exercise of taxing powers. Since taxation is the rule and tax exemption, any tax exemptions unilaterally granted can be withdrawn at the pleasure of the taxing authority without violating the Constitution. Q. A law was passed granting tax exemptions to certain industries and investment for a period of 5 years. But 3 years later, the law was repealed. With the repeal, the exemptions were considered revoked by the BIR, which assessed the investing companies for unpaid taxes effective on the date of the repeal of the law. NPC and KTR companies questioned the assessment on the ground that having made their investments in full reliance with a period of exemption granted by the law, its repeal violated their constitutional right against the impairment of the obligations and contracts. Is the contention of the company tenable or not? Answer: the contention is untenable. The exemption granted is in the nature of a unilateral exemption. Since the exemption given is spontaneous on the part of the legislature and no service or duty or other remunerative condition have been imposed on the taxpayer receiving the exemption, it may be revoked by will by the legislature. Christ Jesus versus Philadelphia. What constitutes an impairment of the obligation of contract is the revocation of an exemption which is founded on a valuable consideration because it takes the form and the essence of a contract. Freedom of the press. Basis: no law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble and petition the government for redress of grievances. Q. RA 7716 was enacted to widen the tax base of the existing VAT system and enhance its administration by amending the NIRC. The PPI questioned the law insofar as it has withdrawn the exemption previously granted to the press under Section 103F of the NIRC, although the exemption was subsequently restored by administrative regulation with respect to the circulation of income of newspaper. PPI presses its claim because of the possibility that the exemption may still be removed by mere revocation of the regulation of the Secretary of Finance, is RA 7716 unconstitutional, for it violates the freedom of the press under Article 3, Section 4 of the Constitution? Answer is no. Even with due recognition of its high state and its importance in a democratic society. However, the press is not immune from general regulation by the state. It has been held that the publisher of a newspaper has no immunity from the application of general laws. He has no special privilege to invade the rights and liberty of others. He must answer for libel. He may be punished for contempt of court. Like others, he must pay equitable and non-discriminatory taxes on his business. Stages of taxation. Stages aspect of a system of taxation. Number 1. Levy or imposition, tax legislation. This refers to the enactment of law by Congress authorizing the imposition of tax. It further contemplates a determination of the subject of taxation, purpose for which the tax shall be levied, fixing the rate of taxation and the rules of taxation in general. Q. Taxes are assessed for the purpose of generating revenue to be used for public needs. Taxation itself is the power by which the state raises revenue to defray the expenses of government. A jurist said that a tax is what we pay for civilization. In our jurisdiction, which of the following statements may be erroneous? 1. Taxes are pecuniary in nature. 2. Taxes are enforced charges and contributions. 3. Taxes are imposed on persons and property within the territorial jurisdiction of a state. 4. Taxes are levied by the executive branch of the government. 5. Taxes are assessed according to a reasonable rule of apportionment. Answer. Number 4. Taxes are levied by the executive branch of the government. This statement is erroneous because levy refers to the acts of imposition by the legislature, which is done through the enactment of a tax law. Levy is an exercise of the power to tax, which is exclusively legislative in nature and character. Clearly, taxes are not levied by the executive branch of government. Assessment and collection, tax administration. This is the act of administration and implementation of the tax law by executive through its administrative agencies. The act of assessing and collecting taxes is administrative in character and therefore can be delegated. Note, the term assessment, which here means notice and demand for payment of a tax liability, should not be confused with assessment relative to a real property taxation, which refers to the listing and valuation of taxable and real property. Q. Is the approval of the court sitting as probate or estate settlement court required in the enforcement of the estate tax? Answer. No. The approval of the court sitting in probate is not a mandatory requirement in the collection of estate tax. On the contrary, under Section 94 of the NIRC, it is the probate or settlement court which is forbidden to authorize the executor or judicial administrator of the decedent's estate to deliver any distributed share to any party interested in the state, unless a certification from the Commission of the Internal Revenue that the estate tax has been paid is shown. Note, assessment and collection may be delegated but not levied since it is exclusively conferred with Congress. Payment, the act of compliance by the taxpayer, including such options, schemes, or remedies as may be legally available. General rule, tax shall be paid by persons subject thereto at the time the return is filed. Exemption, when the tax due is in excess of $2,000, the taxpayer other than a corporation may elect to pay the tax in 2 equal installments, in which case the first installment shall be paid at the time the return is filed, and the second installment on or before July 15, following the close of the calendar year. Note, if any installment is not paid on or before the date fixed for its payment, the whole amount of tax unpaid becomes due and payable, together with delinquency penalties. Refund, the recovery of any alleged to have been erroneously or illegally assessed or collected. or of any penalty claimed to have been collected without authority, or of any sum alleged to have been excessively or in any manner wrongfully collected. Definition, nature, and characteristic of taxes. Taxes are conformed proportional contributions from persons and properties levied by the state by virtue of its sovereignty for the support of the government and for all its public interests or needs. Characteristics of taxes. Number one, it is levied by the state which has jurisdiction over the person or property. 2. It is levied by the state through its law-making body. 3. It is an enforced contribution not dependent on the will of the person taxed. 4. It is generally payable in money. 5. It is proportionate in character. 6. It is levied in persons and property. 7. It is levied for a public purpose. Requisites of a valid tax. 1. It should be for public purpose. 2. It should be uniform. 3. That either the person or property being taxed be within the jurisdiction of the taxing authority. 4. The tax must not impinge on the inherent and constitutional limitations on the power of taxation. Tax as distinguished from other forms of exactions. Tax coverage, an all-embracing term to include various kinds of enforced contributions imposed upon persons for the attainment of public purpose. Tariff, custom duties, coverage, only a kind of tax, therefore limited coverage. Tax object, persons, property, etc. Tariff, customs duties object, goods imported or exported. Definition of tax: an enforced proportional contribution from persons and property for public purposes. Definition of toll: a consideration paid for the use of road, bridge, or the like of a public nature. Basis of tax: demand of sovereignty. Basis of toll: demand of proprietorship. Amount: generally the amount is unlimited. Amount is limited to the cost and maintenance of public improvement. Purpose: for the support of the government. For the use of another property under toll. Authority may be imposed by the state only. Toll may be imposed by private individuals or entities. Note: taxes may be imposed only by the government under its sovereign authority. Toll fees may be demanded by either the government or private individuals or entities as an attribute of ownership. VAT on tollway operations cannot be deemed a tax on tax due to the nature of VAT as the indirect tax. The seller remains directly and legally liable for the payment of VAT, but the buyer bears its burden since the amount of VAT paid by the former is added to the selling price. Once shifted, the VAT ceases to be a tax and simply becomes part of the cost that the buyer must pay in order to purchase the goods, property, or service.